Hello, I'm Amelia Simpson from the ANU Law School in Canberra, Australia, and I'm chairing today's web symposium. Now, given our subject matter today, it's especially appropriate for me to begin by acknowledging the traditional owners of the many different lands from which we are joining today's event. I would like also to pay my respects to elders past and present. Professor Joe Shaw holds the Wesson Chair in European Studies in the School of Law at the University of Edinburgh. Her new book is titled The People in Question, Citizens and Constitutions in Uncertain Times. And this book is the centrepiece of today's symposium. I'll first be asking Professor Shaw to provide us with an introduction to the book before inviting 4 commentators to offer some reflections and analysis. We'll then have time available for your questions and comments before we close at 6:30 p.m. Canberra, Sydney time, so 1.5 hours from now, wherever you are. Professor Shaw, over to you.
Thank you very much, Amelia, and thank you to ANU College of Law for putting this event together. I'm just going to make some remarks to introduce the book about which we're talking today, which has been published by Bristol University Press in the UK, but available worldwide as both a physical book and as an ebook, which is called The People in Question, Citizens and Constitutions in Uncertain Times. And I've increasingly come to believe over the last few months since the book has been published that perhaps my subtitle is even more pertinent than my the actual title of the book. So I hope you'll forgive me if I spend a little bit of time explaining the basic premises of the book, and then that will allow the commentators to have their reign, and they themselves certainly don't need to spend any time describing the book, because I hopefully will have done that faithfully already. So my book talks about the multiple and in some ways surprising and previously under-researched linkages between citizenship and constitutions. And I do so through the prism or lenses of a concept I build called constitutional citizenship. Now, I've found that despite the intuitive connection between citizenship as constituting the membership of a polity and the constitutional laws that frame the legal systems of states and other polities, in practice, it can be hard to pin down exactly what the meaning of constitutional citizenship may be in either individual cases or as a general phenomenon. This is in part because constitutions rarely provide coherent detail on the nature of the membership status or the rights attaching exclusively to it. The linkage between the idea of a democratic people under a constitutionalized polity and the formal bounding of the polity through a membership status is often made implicitly rather than explicitly within constitutional law. And that distinction, I think, is quite important, and I hope we're going to explore that during the course of today's events. So, for example, references in constitutions to equal citizenship are often not fleshed out. And there are very few references to different modes of acquisition and loss in the majority of constitutions. So just to give an example, a hypothetical polity, a typical hypothetical polity would simply say in its constitution, citizenship of the state of Ruritania, for argument's sake, is hereby established. And then there's nothing else explicit in the constitution. There is a citizenship, but we know no more exactly what that means. And some states don't go as far as that. And the state in which this event is being rooted in, as it were, Australia, is an example of that. And I know that one of the commentators at least will make reference to that. So just because the linkage between constitutions and citizenship is not made explicitly, is not a reason why we shouldn't explore it in more detail. So I would argue that the constitutional citizen is a central figure for understanding many dimensions of and tensions within modern citizenship, as well as for understanding modern constitution-based polities. So hopefully my analysis makes us understand more about citizenship and more about constitutions. What it does mean is that this prism and the absence of detailed regulation in constitutions is that the range of legal sources that we have to examine is rather substantial. So we can't only look at the formal rules in a written constitution, but also at general constitutional norms, which are often engineered by courts. We also have to look at fundamental rights norms stemming from a variety of national and international sources, case law in general, legislation, and even administrative and executive practice. All of these sources of law can have constitutional significance. Part of the challenge of identifying constitutional citizenship is undoubtedly related to the great variety of constitutional and citizenship regimes, in addition to the conceptual problems that the idea raises. Furthermore, under conditions of autocracy or authoritarianism, where constitutions may also play the function of suppressing rather than embracing pluralism, the democratic dynamic of citizenship is significantly changed or completely absent. The constitutionalization of citizenship represents one of the conduits by which states continue to pour meaning into the vessel of citizenship, filling it out in ways that are not always congenial to adherence to liberal democratic principles. Indeed, it may be more helpful to think of constitutional citizenship more in terms of process rather than as a finality. This helps to maintain a degree of flexibility regarding the diversity of contingencies affecting national citizenship regimes, all of which render the setting of general dispositions about constitutional citizenship rather challenging. But I will argue, and I argued in the book, this does not undermine the heuristic or interpretative power of the concept. But we need to be aware of the iterative and ultimately circular character of the task of interpreting and reinterpreting concepts of citizenship, and of the constitutional principles such as equality and dignity, which I analyze alongside it, which many argue underpin the normative and normal incidents of citizenship. And altogether, these add up to a status in each polity which is special, equal, and persuasive, or at least it is in theory. And there I was quoting from the political theorist, legal theorist, Jeremy Waldron. What renders the task of achieving a more detailed and granular understanding of the relationship between citizenship and constitutions than we have at present more important, in other words, this is the reason why I wrote the book, other than to describe the relationship between citizenship and constitutions, what makes that more pressing are the pressures upon the modern paradigm of state-based citizenship that we have at present. I argue that these stem first from what might be termed the shifting spatialities of the governance of citizenship, and second, from what some may call the populist moment in which many countries, if not the world in terms of how we are currently staring at the American election, in which many countries find ourselves. So the shifting spatialities of citizenship challenge the territoriality of states. We can observe the dispersal of authority to determine the scope of citizenship as status and rights through many levels, subnational, national, supranational, international, and so on, as well as intensified transnational connections between citizenship regimes, not least because of the rise of human mobilities of various kinds, which of course raises the question of what do we do, how is citizenship affected when human mobilities decline rather than rise? States no longer have, if they ever did have, an unfettered sovereign capacity to determine authoritatively the boundaries of the polity without regard to what other actors do. To a certain extent, individual and group claims making has also followed this trend, with the identification of the European Union, which is the sphere that I know best, for example, as a significant source of citizenship rights. Shifting spatialities reflect both top-down and bottom-up shifts in the meaning of citizenship. And in that context, I'm sure we're going to reflect upon some of the meanings of the pandemic of COVID-19 for this whole space. The second reason is for pursuing this articulation has been the rise of populism as an important space or ideological space or ideational sphere or style of politics, if you will, which and that's the point on which I will conclude these comments. Just to link that perhaps more intimately to the COVID-19 pandemic than we might otherwise do, there have been fears that there is a risk that attempts to combat the spread and impact of COVID-19 will not only be associated with a return of the state in a functional sense, but also with the resurgence of nationalism in the ideological sense of an effort to give meaning and identity to the purported congruence of the territorial state with a nation, and with the rise of populism in the sense of the identification of a pure people. Both nationalism and populism, although contested ideas, retain deep and enduring links with citizenship. The conduit is the concept of the people, so we come back to the title of the book, The People in Question. There are intimate links between the invocation of a pure people, unsullied by a corrupt elite, on the one hand, and the role of the people in democracy and in constitutionalism. The populist certainty about who are the people contrasts sharply with the multiple competing frames of the role of the people within many constitutional setups, as popular sovereignty, representative democracy, deliberative democracy, direct democracy, and so on. It also contrasts sharply with complexity involved in reconciling the idea of a bounded polity with concepts such as universal personhood or fundamental rights. It follows from populist certainty about we the people that the populists will often succeed in narrowing the discursive space around the idea of the people by reference to how they define the true people. Outside the true or pure people, who are undoubtedly, of course, like any people, an imagined construct, there may be elites whose claims to belong may not be contestable, but whose claims to represent can be challenged, however hard they work to render themselves accountable. There are also those persons distinguished by a range of vectors, such as ethnic belonging, religion, or immigrant background, whose very claim to be part of the people is under threat, even if they possess the formal badge of membership. The call to draw such distinctions and to enshrine them where possible in law and constitution marks the political platforms of most populist political parties operating in an electoral context. Where populist parties have governed, because their offerings have proved popular with the electorate, we have often seen them tinkering directly or indirectly with aspects of the regime which governs citizenship status and rights. For example, in order to make it harder for some people to gain access to formal citizenship status, or to challenge the political, civil, or social rights of certain categories of others who are deemed less worthy. In the book, I discuss quite extensively the case of Hungary. In some cases, this is done directly by reference to a narrowing of the circumscription of membership in a constitutional context, with a view to recalibrating the national notion of people and indeed the very idea of constitutional identity within that particular state. This is certainly true in my judgment about Hungary. In this way, the concept of the people offers not only a bridge between citizenship and populism, but also between constitutionalism and populism. And there, in essence, is where I I bring my book in the conclusions to a judgment about what types of ideas are useful for narrowing that discursive space. Insofar as I make a normative judgment about constitutional citizenship, I'm fairly clear in my book that we need to have a pluralist approach to questions of constitutional identity and the identification of both the status and rights and identity of the constitutional people. So I hope that that's given you something of a flavor, and I'm looking forward to hearing the comments and to responding in Q&A.
Thank you, Professor Shaw, for that engaging and crystal clear introduction. All the more remarkable when we remember that it's 6 o'clock in the morning where you are in Edinburgh. Let's turn now to the first of our 4 commentators. Dr. Jaclyn Neo is Associate Professor of Law and Director of the Centre for Asian Legal Studies at the National University of Singapore. Jaclyn.
Thank you, Amelia, and thank you to ANU for inviting me to be part of this. First, I would like to congratulate Jo on this tour de force of a book examining the relationship between citizenship and constitutions. This is a book for the times. It provides a masterful sweep of current literature on citizenship, which is plentiful, and how it intersects with constitutions. And of course, Jo has already given a really good overview of her primary arguments in the book. But I will encourage you, if you haven't already, to get a copy of the book and read it, and even pay attention to the bibliography, which I thought was a comprehensive overview of existing scholarship and really a way to get yourself acquainted with what is currently out there. Now, for me as a constitutional law scholar, Jo's book provides thought-provoking examination of this relationship between citizens and the Constitution, encapsulated in what she refers to as constitutional citizenship. Now, this is a very important endeavor, considering that almost every country in the world has some claim commitment to some constitutional structure, whether written or unwritten. The citizen, as Jo rightly points out, should be at the core of constitutional government, and it is imperative that we examine carefully what the Constitution says about it. And so, as she explains in page 61 of her book, she explores 3 interrelated sets of questions concerned with constitutional ideals and identities, the definition of who are and who are not citizens, and the challenge of identifying citizenship in terms of rights and duties. Now, these are big questions, and as Jo points out, not always fully examined or even appreciated in current scholarship. And I appreciate that her analysis is multi-layered. Indeed, when one examines what the Constitution says about citizenship, one has to go from the text to context, words to practice, from institutions to institutions, legislature or the executive to courts. And Jo points to this multiplicity of constitutional practice and the sources, suggesting that citizenship should be centered more squarely in constitutional analysis, rather than be left to the potential vagaries of legislative power. Now, in responding to this big set of questions, one recognizes that it is no mean feat to try to address them in a manner that is not jurisdically bounded or even regionally bounded. And so one thing I really appreciate about Jo's work is that she tries to go beyond what in comparative constitutional studies Herschel calls the usual suspects. She acknowledges the importance of distinctive historical and political features beyond the usual suspects, be it post-colonialism, non-liberal democratic constitutions, communitarian commitments. But since this is a book, not a 10-volume tome, it is of course not possible to go in depth into all of these differentiated contexts. But Jo's book gives us important insights, and I think sufficient thought, provocative thought into these divergent issues. And it is my hope that it would provoke further scholarship in this area of constitutional citizenship. Now, another aspect that I appreciate in the book is the mutually constitutive nature of the subjects of analysis. This at various points. For instance, Joe highlights how constitutional values have an impact on how the polity views its citizens, and at the same time, how the treatment of citizens shapes constitutional values. In other words, I see the work as calling upon us to consider both the citizen in the Constitution as well as the Constitution in the citizen. Now, of course, citizenship's precise meaning is often contested, and though, as Linda Bosnia has put nicely, that its normative valence is never in question. And so the substantive core of citizenship in designating some form of membership, rights, privileges, and duties is always central. But sometimes that focus sort of goes outside of law, which is important. But I think this book itself counsels us or encourages us to look at the Constitution also as a legal document, because it is the Constitution as well as law outside of the Constitution which prescribes the very basic essentials of citizenship in terms of modes of acquisition, deprivation, and the bundle of justiciable rights and legal duties. And these may not be experientially salient in everyday life all the time, but they become existential ones. For instance, when one seeks to attain citizenship, whether for yourself or your family, or when one loses one's citizenship. And in those circumstances, what you want is the law, preferably the Constitution, to say something about how to navigate the situation. And hopefully, it provides a process and content that is fair and equal. And so, as Jo rightly points out, she draws attention to citizenship as a lived practice, but as one that is shaped and determined by the framework of the legal constitution. Now, I get that Jo makes it clear that her work is not meant to be normative, and she recognizes at parts however, that any interpretive exercise necessarily encompasses, I would say, some normativity, right? For instance, she says, the modern ideal of citizenship demands a form of equality defined by reference to universal personhood, highlighting that constitutional norms that underpin citizenship include dignity and equality. Now, these are big concepts, dignity, equality. And we do know that these are norms that in some cases could also be contested. And so to include them in the analysis itself is highly ambitious. Now, at the end of the day, there is also a question of whether these norms should indeed intrinsically be considered part of the ideal of citizenship, or whether they're just one possible bundle of norms that some would associate with citizenship. So some may point to the liberal versus non-liberal or communitarian citizenship debate in challenging these claims. And in one way in which I think constitutional citizenship may wish to take these sort of non-liberal or communitarian perspectives even more seriously, I suggest, will be to think more carefully about the idea of constitutional duties. One stark example is, for instance, compulsory military service that is still practiced in several countries in Asia, including Singapore, South Korea, and Taiwan. Now, compulsory military service is often constitutionally enshrined and itself has become a site of construction for a thicker sense of citizenship. It is not only the constitutional duty of the citizen, but also has become a marker of citizenship. And so I think the idea of constitutional duties is an area that would deserve closer examination and would further enrich the analysis on constitutional scholarship. Now, in the remaining part of my remarks, I want to sort of connect Jo's work with contemporary events, which she has already pointed to. Something that we must all be tired of living through right now, and yet hopeful. There was just a new announcement that a vaccine might just be around the horizon. Now, the COVID-19 measures and what that says about constitutional citizenship. What fascinates me about state reaction to COVID-19 is how practically relevant and normatively salient citizenship remains. And in all of this, constitutional scholarship remains key. As Jo points out, the unconditional right to return is one of the few rights given exclusively to citizens, though she also acknowledges that patterns and processes of denationalization and deportation have rendered even that story much more complex in recent years. Now, in a recent book chapter on borders and COVID-19, my co-author and I pointed out that under pandemic conditions, a climate of fear might aggravate an us and them mentality. And we see this whereby the foreigner is no longer just a distinct unknown other, or even potentially the source of competition for livelihood, but also could now be seen as harbinger of death. And so we see how state responses have been built primarily around distinctions between citizens and non-citizens, and secondarily among different categories of non-citizens. Citizenship therefore becomes critical in claiming and receiving rights and entitlements against the state. I thought it was fascinating in March and April, with cases of new coronavirus spreading quickly around the world, a growing number of countries had a simple message for their citizens: come home. Come home. It was a call to all with legal status. And so let me just end by highlighting three very important aspects of this message of coming home and how it points to the importance of having a constitutional perspective to citizenship. First, in some countries, only citizens were legally entitled to enter a country. Now, this is consonant with international law, such as Article 12 of the ICCPR, but it more importantly than the international law is the focus on constitutional text. We see various constitutions that prohibit the banishment of or exclusion of citizens, such as the constitutions of Singapore, Malaysia, and Thailand. And indeed, in these countries, citizens were allowed to enter. And even where the constitution is not explicit, we do have certain courts that have implied the right to a free entry into the constitution. The Supreme Court of India, for instance, has inferred a right of re-entry from the right to reside and settle in any part of the territory of India. Now, the right to re-entry is typically not usually a very controversial right, but in this pandemic world that we live in right now, the right to re-entry has become one of these key entitlements that are available to citizens. And the fact that in some situations, the Constitution provides for this right becomes especially important for litigation, for claiming it as a justiciable right against the government. Now, secondly, most travel restrictions were aimed at entry, but there were also some governments which imposed exit bans, which is far more controversial. This means that they would ban nationals from even leaving the country. Now, prohibiting exit could be challenged as unconstitutional insofar as some constitutional documents do provide for this right. For instance, Hong Kong's basic law guarantees all residents the freedom to travel and to enter or leave the region. The Japanese constitution enshrines freedom of persons to move to a foreign country. Now, interestingly, what we see here is that in certain circumstances where there is no such constitutional right, where courts have refused to imply this right into the constitution, governments have imposed and have claimed the power to prohibit their own citizens from living. And one such example is in Malaysia, where it has been held in the 2017 case that there is no constitutional right to travel abroad. And so we see this being played out with the conditional bans, travel bans in Malaysia, which also prohibit their citizens from leaving. And so I thought I should conclude with a prescient passage by Jo, where she says, discrimination and differentiation are back with a vengeance. along with the prizing of national citizenship as a legal status. And this time with a clear impact, not just on the outsiders, the immigrants, but also on certain categories of insiders, such as naturalized citizens or the children of immigrants who may be seen by policymakers as still just too foreign to be authentic citizens. Indeed, I've only pointed to a few instances in which the COVID-19 measures raises these issues, but if we look at how governments have responded to the COVID-19 and type of measures that have been put in place, we do see them bringing together many of the themes Jo discusses in her chapters, including those on populism and shifting spatialities. Now, I must clarify that her book ends with a much more positive note, I think, and applaud, for instance, her advocacy for a much more pluralist idea of citizenship. But I think the call to focus on constitutional citizenship is an important one, and we should do well to take it seriously. Thank you.
Thank you, Jaclyn, very much for those very considered thoughts. I'm sure that Jo has things she'd like to say in reply, but I think I will ask her to wait until we have heard from one more of our commentators, and then I'll give Jo an opportunity to weigh in if she'd like to. So I'd like now to introduce Dr. Julia Sardelic, who is a lecturer in political science at Victoria University in Wellington, in New Zealand. Julia.
Thank you very much, Amelia, and thank you very much, Jaclyn, for a very interesting comment. And I would just first like to say kia ora koto katoa, good evening, and warm greetings from Aotearoa, New Zealand. Before I start my comment, I would like to congratulate the organizers for putting together a symposium that includes speakers who have up to 13 hours time difference. I think this is not an easy endeavor, and I would especially like to thank Jo Shaw for being here so early, 6 in the morning, as Amelia mentioned, so I can also participate in the middle of the night, as sometimes happens with New Zealand being on the other end of the world. Of course, I would like to also thank Jo for writing such an amazing, thought-provoking book, and it is a privilege that we can be here today with all of you, and I can express the thoughts as a reader of Jo's book. In my comment, I would like to focus on two things. First of all, I will pose a question: how can Jo's understanding on the interrelations between citizenship, constitutions, as well as definition of people can help us contemplate the position of marginalized minorities? Second, I will look at how can future generation of citizenship scholars engage with Jo's fascinating book. My comments will probably also give away my secret, that is that I'm not a legal scholar, but I describe myself usually as a political sociologist. And while I think that my thoughts will be within the domain of socio-legal analysis, it might be more leaning towards the side of socio than legal. So I hope you forgive me for that. I would like to start my comments with two examples that were constantly coming back to me in my mind while I was reading Jo's book, and as I think that actually illustrate constitutional citizenship, as well as the troubled relationship the concept sometimes has with how people are constituted and reconstituted in turbulent times. The first example focuses on a court case at the European Court of Human Rights, Hudorovic and others versus Slovenia. Roughly speaking, the case was about the right of two Romani communities in Slovenia to access drinking water. Slovenia is usually described as an EU member state that became a new EU member state in 2004 and was considered as a wonder child of post-socialist transition. In 2016, the constitution of the Republic of Slovenia was amended to include the Article 70A, which is the article about the right to drinking water. So the article reads like this: everyone has the right to drinking water. Water resources shall be public, good, managed by the state as a priority and in a sustainable manner. Water resources shall be used to supply population with drinking water, and water for household use in this respect shall not be market commodity. The supply of population with drinking water and water for household use shall be endured by the state directly through self-governing of local communities and on a non-profit basis. Now, this article has been, in the Constitution, has been described by many environmental activists as extremely progressive, but at the time it was forgetting that Slovenia, as many other European member states, has a minority community that around of which 75% does not have access to drinking water. European Roma Rights Center has reported similar numbers all around Europe, and the response of the Slovenian government in the court case pointed out, I'm quoting, that illegally constructed buildings were not allowed to be connected to public utility infrastructure facilities such as drinking water supply and the discharge of wastewater, emphasizing in this regard that the applicable laws applied uniformly to everyone, further arguing that any provisions to the contrary would amount to discrimination against majority vis-a-vis the Roma community. Now, this is interesting because the court decided in favor of the Slovenian government, and the European Roma Rights Centers and other NGOs said, how can, for example, Romani minorities who are EU citizens in different European member states, for example, wash their hands in the COVID-19 pandemic, when this is one of the main advices when they do not have access to drinking water. I wanted to highlight this because it also brings to the argument that providing equal rights to a marginalized minority would be discriminatory towards the majority citizens is not new. Similar statement was actually made by settler colonial states governments of United States, Canada, Australia, and New Zealand when they in 2007 rejected the UN Declaration on the Rights of Indigenous People. For example, the representative of New Zealand commented that the right to free, prior, informed consent would represent a veto power for Maori people that would discriminate against the majority Pakeha population because they do not have these veto rights. I brought these two examples forward first because it actually illustrates how I was reading this book. And I was actually thinking about the theoretical consideration of Roland Barthes and reader's reception in his classical work as Z, because it seems to me that in academia we have now three types of books. Some books, the first type leave us unimpressed. The second types, like in the end, we read and take what are the lessons from this book. But the third type, which is in my perspective, the best books are like a journey, and constantly the reader is in dialogue with the material that he or she has read. Joe's book, being so empirically rich, but at the same time conceptually and theoretically innovative, certainly made me to be in dialogue with the material that I have read and constantly provoked me to think what else can be explained with the concepts of constitutional citizenship as well as reconstitution of people in turbulent times. First, I really appreciate Joe's positioning on the context of reading the constitutions and how citizens are within it. Because, for example, Constitution of Slovenia mentions citizens and citizenship 24 times, but it does not define it. And without the context, we could not understand that Roma are not a privileged minority over majority. And also similar can be concluded for indigenous people, as Carvin Jones, who is a Maori legal scholar, highlighted that without considering the context, when discussing constitutional design of Aotearoa, New Zealand, Tikanga Maori, which is the basis for indigenous law, could be completely ignored. It seems to me that very rarely we can see in the scholarship, also Devyani Pravat pointed out to this in the review, her review of Joe's book, is that we could bring these two concepts together, but also many different contexts are very rarely brought together as introduced in Joe's book. The next thing that I really appreciated about Joe's book is how it recentered certain debates and how they should focus on citizenship rather than, for example, migration or like exceptional marginalized minorities. For example, the Windrush scandal is much more a question of how multi-layered the British citizenship is, so colonial division between subjects and citizens, rather than in the domain of migration studies. Similarly, I appreciated how she engaged with the figure of non-alien, non-citizen with the two cases of Loth and Thoms versus the Commonwealth, as you know it quite well in Australia. Such novel reading is important as it is too often a position when we talk about marginalized minorities that it's viewed from the perspective of exceptionalism rather to what is constitutive to citizenship, as I also argue in my forthcoming book, The Fringes of Citizenship, which is coming out next year. The two examples I also believe are very much connected to the other part of the main argument of Jo's book, is how the molding of people is happening in the turbulent times. And I think that we can connect this also to what she talks about when she talks about loss of citizenship and statelessness, because it is really the repositioning of people and the understanding of people that has brought cases of statelessness, minority statelessness, may I add, in the cases of Rohingya in Myanmar, Dominicans of Haitian descent in Dominican Republic, and nevertheless Roma after the disintegration of former Yugoslavia. Here, I would like to conclude with a question to Jo, because I would like to ask you, Jo, how do you see the future life of your concept, constitutional citizenship, being applied in the future scholarly literature, and how will the concept of people be changing, especially considering the position of marginalized minorities, and especially after 2020? And I would just like to conclude that I see this wonderful book being a signpost for many future generation of citizenship scholars, and I would like to thank Jo for that. Thank you very much.
Thank you, Julia, for that wonderfully evocative commentary on Professor Shaw's book. I'd like now, before we go to our final two commentators, to give Professor Shaw an opportunity to engage with Jaclyn and Julia's comments. Jo, is there anything that you'd like to say in response or to add?
I'd like to thank those commentators for those comments, and say that they're very much pushing at areas where I think there is a lot more work. I mean, just starting with Julia, because it's most recently in my mind, I think this idea about exceptionality for minorities and how that works in a constitutional context, as well as the implications of international law. And so this multi-level governance of citizenship is I think an area which certainly, had I been writing a 10-volume tome, I certainly could and would have wanted to explore in more detail. And the example that you give around the right to water, I think is articulates the relationship between, certain emerging social and economic rights and the very nature of citizenship, and that's hopefully where the concept might go in the future, as well as, I think, inevitably it's going to be explored in the context further of what's happening with the pandemic, as Jaclyn says. I mean, those examples that you give from ins and outs, if you will, are really illuminating. And the other group that one could look at in that context, I mean, you talked about the coming home thing. You can also look at examples where diasporas have been encouraged to stay put, because what the diaspora is delivering is massive remittances, and therefore if the diaspora doesn't stay put and the remittances stop, not only will there be costs associated with the diaspora coming home in terms of quarantining them and them providing healthcare, which people have obviously become more alert to, but it will upset one of the sort of fundamental infrastructural elements of the current global capital system, which is the contribution of remittances to the maintenance of the sort of client. There's a sort of agent principal relationship, I think, going on there within global capital and within the sort of framework of the global system of states. And I would add the position of diaspora in as a very interesting, sometimes vestigial and sometimes central community there that one could discuss. I've been thinking about those things a little bit more, and I hadn't realized you'd written on that already as well, Jaclyn. So we'll be in dialogue by email after this, because I very much like to look at your draft paper. It sounds very, very interesting. There were a few sort of other points that I would want to. Oh yes, I just have one more thing to say about borders and non-citizens, and that is Danish mink, because this idea of an entire population, an entire quotes national population of a certain animal, which is being produced for you know, in order to facilitate a luxury good, namely mink coats. And I had no idea that mink coats was still a big thing, or indeed that Denmark might have 70 million. And of course, the main market for those mink coats is, guess what? China. Interesting how these things are circulating. In other words, the circulation of global capital and the sort of, you know, globalization it keeps coming back to us in the context of the pandemic in interesting ways. And of course, these mink have now become a symbol of death again in their own way. And this is absolute. So the contestation over whether the farmed mink must die is a very interesting one that's going on in Denmark. And it also helps to bring out the ridiculousness of many governments' positions. So the UK has now decided that no one, not even elite sportsmen who've been in Denmark, should come to the UK if they're not British. But of course, if you're British, then that's different, you know, even though what we're trying to raise the threat of mink into an existential one. Mink are going to threaten you. They are quite, well, we have wild ones around our building on the river and stuff, and you can hear them. And that's right in the middle of the city. You can hear them. They make quite a racket at night sometimes. And now they've become an existential threat to us, but not if the existential threat is potentially carried by British citizens, only if it's carried by aliens. So that, in a sense, I think is another area to pursue. I've marked up a couple of other things, and I suspect we'll probably get to talk about those in the context of the other two commentators, and I won't sort of shoot the bolt. I've got notes here about the role of courts. I suspect maybe that question might come up in the context of both Murray and Rayner's questions, and about the tension, this constant tension in citizenship between universal personhood and bounded communities. And again, I suspect that that's going to come up in further comments. So rather than saying any more, I think I'd like to hear what the others have got to say. Thank you.
I agree, Jo. So I will pass the floor now to our next commentator, Dr. Rayner Thwaites. Rayner is a senior lecturer in law at the University of Sydney, and his research focus overlaps considerably with Jo's interest and focus. So let's hear, Rayner, your thoughts.
Jo's book, The People in Question, is generous and wide-ranging, and it's a pleasure to be part of this panel and to be part of some of the discussions the book will generate. So I want to do two things this evening. I want to engage with Jo on how much detail we might expect about sort of citizenship in the Constitution, and how we might pursue it. So they're not small questions, but I'll anchor it down with examples. So in the conclusion to Jo's book, she outlines some puzzles which have sort of spurred her to write. One of them was, why is it that citizenship is so rarely regulated in substantive terms within constitutions themselves? And then this question breaks down into a number of narrower questions. So she considers, well, why is citizenship so often dealt with indirectly, such that you need to assemble the pieces from different sources? And, you know, is that because it's taken for granted, or why is that? So I'll lead with some examples that offer what is very much a sort of an initial, partial answer, which will raise further questions. So to take the first, why is citizenship so rarely regulated within constitutions sort of in much detail? Well, it's an obvious point, and it's one that Jo is very much alive to, but one of the issues is regulating citizenship in detail can go badly. So at the outset of the 20th century, with Federation 120 years ago, the newly constituted Australia adopted a constitutional disqualification on the subjects or citizens of a foreign power being chosen or sitting in the national parliament, contained in section 44(1) of the Constitution. Now, if we fast forward over a century, dual citizenship is no longer a matter of opprobrium. Australia is now a country whose citizenry is characterised on best estimates by one of the highest proportions of dual citizens in the world. And this conjunction, as Jo's well aware, led to the disqualification or resignation of 16 members of the 2016 Parliament, and is attributed sort of going forwards on good grounds with a chilling effect on parliamentary candidates of migrant background. Recommendations for constitutional amendment to remove the requirement have, and again, as Jo notes, issued from parliamentary committees. She cites one in 1997, but going back even earlier to remove the requirement or to amend the Constitution. But even with the parliamentary carnage that we saw in Australia in 2017, the prospects for change are sort of in the middle distance at best. So, that's a case where I don't think I'm alone in wishing that hadn't been constitutionalised, or at least had been introduced by the phrase until the Parliament otherwise provides. So there's sort of, there's just the basic point that, which is attested to by many examples in Jo's book, but you sort of need to feel your way forward carefully as to what you constitutionalise and what you don't in relation to citizenship. Then there's a more general issue, again, which is surfaces and is negotiated in Jo's book, of the very real exclusions that you can end up with when you tie rights to citizenship, where that leaves those who are non-citizens. We sort of were discussing before we went live the US elections on the 3rd of November. And one little reported aspect of those elections was that 3 states voted to modify their state constitutions to include a citizenship qualification of electors. So Colorado's constitution, before November, used to say, every citizen of the United States who has attained the age of 18 years, has resided in the state for such time as may be prescribed by law, shall be qualified to vote. So that secured the state and local franchise to US citizens, but it did not, in its terms, deny it to others. Following the successful passage of the amendment, which was voted on at the time of the election a week or two ago, it will now read only a citizen. So for every citizen, they've substituted only a citizen of the United States who has attained, and goes on, shall be qualified to vote. And voters in Alabama and Florida approved similar amendments. Now, there are disputes as to the practical effect of these measures, the actual change it affected, but it serves in a rather sort of heavy-handed and obvious way to show that constitutionalisation and tying rights to citizenship is capable of restricting rights and restricting people's rights in a deliberately exclusionary way. So, just to sort of offer the observation, there may be good reasons centred on regard for non-citizens for not constitutionalising rights, certainly as an instant of citizenship. Now, that's not to say, and I don't think that there aren't some good candidates of aspects of citizenship that are ripe for constitutionalisation. And so I'll have more to say, but I'll put up now my first question for Jo is, she states in the conclusion to the book that she's worked hard, not to impose her own views, but, part of the attraction of a panel, Jo, is you can speak off the cuff, you can say things. And as a first question, I'd be interested to know whether, coming out of the writing of the book or otherwise, Jo, you have any general candidates, sort of, not tied to sort of particular historical specificity of a particular jurisdiction, but whether you have general candidates for incidents of citizenship that merit constitutionalisation, things that you think are good candidates for the kind of things, the kind of aspects of citizenship that should be constitutionalised. So a second, and my second and last sort of thing to look at is sort of the how question. So, Joe also asks, well, why is the constitutional substance of citizenship, why does it so often reveal itself indirectly? And I think at least part of the answer can be found in a large question that Joe registers as hanging over her book, namely the relationship between majoritarian and non-majoritarian institutions as regards the constitutive qualities of citizenship. And again, drawing on Australian law, a great example can be found in the case law on directly chosen by the people in sections 7 and 24 of the Constitution. So if I'm thinking of the case law from the Vicky Roach case of 2007 and onwards. The phrase directly chosen by the people in those sections has served as a textual basis for entrenching a near universal adult citizen franchise. It's been used to invalidate blanket prisoner disenfranchisement, to anyone given a custodial sentence in the Roach decision, and it's been used to invalidate attempts to close the electoral rolls earlier than had been allowed under a previous durable legislative practice in Roe. In these cases, which are analysed by Elisa Arcioni and others, the Parliament is, and this is the reason for raising them, the Parliament is allowed to define and shape the content of the norm as it relates to citizenship in the franchise. But then gains in both the scope of the franchise and the procedural machinery that attends voting are subsequently constitutionalised in the sense that any departure from the universal franchise or from durable legislative practice calls for forms of justification that are familiar to us from constitutional rights jurisprudence. So to put it in terms of Joe's question, the indirectness of constitutional protection, which she sort of raises as a puzzle, in that case is a function of sort of attacking back and forth between the elected legislature and constitutional protection. The legislature develops and supplies the content, which then receives constitutional protection, and there's sort of a movement back and forth between legislature and courts in a constitutional role. And just the relationship between statute and constitution can, of course, be uneasy, as exemplified by a judgment which Julia mentioned and Joe discusses in the book, the Love and Tom's decision. So the split in the judgments, the majority allowed for a pre-political, in the sense of pre-legislative membership of the polity, defined by indigeneity and independent of statutory citizenship. That's the central point here. Whereas the dissents all effectively took the view that statutory citizenship now completely determined the constitutional concept. So there's tensions between the statutory understanding of citizenship and constitutional citizenship. There's more to say, but I think I'll turn over now and just to close, just thank Jo for the book. Meeting her in person 2 years ago, it was great to have her in Sydney for a while, and it's wonderful to be able to now see and talk about what she was working on at the time. So thank you very much and for being part of the panel. Thank you.
Great, thank you, Rayner. Some very interesting things there. I'm sure Jo will be keen. Oh, Jo's got her book as well.
Yeah, I just wanted to say that the book shows the, oh, it doesn't, sorry, I've got a
Rayner's got the book. Rayner, hold yours up.
Shows Sydney Law School.
Yeah.
Yeah.
That's the Doug Hammarskjöld Plaza inspired artwork. Okay, yeah. Sydney Law School, yes. Now I'll ask Jo to hang on to her thoughts and responses on Rayner's provocations, and I will invite Dr. Murray Wesson who's senior lecturer in law and deputy head of school at the University of Western Australia, to take over now and provide our final commentary.
So thank you. I'd like to acknowledge the traditional custodians of the land where I am, the Whadjuk Noongar people, and pay my respects to their elders past and present. Thank you to the organisers for the opportunity to participate in the seminar, and to Jo Shaw for the opportunity to comment on her book. And like everyone else, I would like to say how impressed I was by this book. And I think especially just by the extraordinary range of comparative materials that were drawn into the analysis. Coincidentally, actually recently became an Australian citizen about a month ago. So I'm now a dual national of Australia and South Africa. And apart from the controversies about dual nationals here, I was surprised to read in the book that as recently as 1974, this category was described by the German Federal Constitutional Court as an evil that should be avoided or eliminated. So I've been thinking about citizenship in a fairly unsystematic way, and this book has enriched my understanding a great deal against that background. So I just have two sets of interrelated comments, and I think they both relate to threads that have been raised already. The first is a question about methodology, and in particular about the sort of at times uneasy relationship between the descriptive and normative elements of the analysis. So as Jo explained at the outset very clearly, the book sets out to explore the concept of constitutional citizenship, but at a purely descriptive level, what we discover is that constitutions are fairly unspecific in what they have to say about citizenship. And so in that sense, constitutional provisions on citizenship constitute a discursive space within which the meaning of citizenship can be revisited and reformulated. But as Jo notes in her conclusion, the book is not a purely descriptive one. It's also intended to be interpretive and critical. And in particular, it seems to me that a normative element is introduced through the emphasis on the norms of dignity and equality. So I did find myself reflecting on how to understand the sort of methodological elements of the book that are involved in arriving at an understanding of constitutional citizenship. I mean, one question might be, or one understanding might be, that what this book seeks to do is merely to present the core or paradigm case of constitutional citizenship in terms of modern constitutionalism. And I don't think that's quite right, because I don't think that what Jo is doing in this book is simply aggregating as many constitutions as possible and then seeing what comes out the other side. So then I also found myself reflecting that maybe this is a type of Dworkinian project, and you'll have to excuse me for this because I have been teaching legal theory this semester, but Ronald Dworkin argues that when we seek to understand interpretive concepts such as law, we look for the interpretation that fits the relevant materials, but also shows them in their best or most morally appealing light. And I thought perhaps one way of understanding what this book is seeking to achieve through the extensive survey of comparative material is to find an understanding or conception of constitutional citizenship that fits these diverse materials, but also arrives at a morally attractive understanding of the nature of this discursive space as informed by these norms of equality and dignity. Of course, as I think was also noted by one of the commentators earlier in this discussion, norms of equality and dignity are understood differently in different jurisdictions, and less or more emphasis is placed upon them in different jurisdictions. So for example, in Australia, although we have had some references to dignity as a value in some recent decisions relating to the implied freedom of political communication, not so much in the sphere of citizenship, these values play a fairly muted role. And I suppose that gives rise to a question about how, from an Australian perspective, we should understand the conception of constitutional citizenship that the book presents. As one perhaps that we are slightly peripheral to, or perhaps one that we should seek to emulate to some extent by finding ways to inject a greater emphasis upon equality and dignity into our own constitutional law in respect of these issues. Now, for the second part, I wanted to turn to a jurisdiction where norms of equality and dignity, in fact, hold fundamental significance, and that's South Africa. And they hold that significance against the background of apartheid, where those rights were systematically violated. And as Jo notes in The People in Question, when she discusses South African constitutional law, under apartheid there was a divided citizenship, and as a result of that, Section 3 of the post-apartheid constitution establishes a common South African citizenship where citizens are equally entitled to the rights, privileges, and benefits of citizenship. And so I think South Africa is a prime example of a jurisdiction where the rights to equality and dignity fundamentally inform the discursive space of constitutional citizenship in a way that perhaps is less true of a jurisdiction such as Australia, although there are people on this panel who know more about this area of Australian constitutional law than I do. But having reviewed the cases after reading Jo's book, one interesting aspect that I wanted to note of the South African jurisprudence is how these rights to equality and dignity have not only given content to citizenship, but also in some cases chipped away at the boundaries between citizenship and other classes of residents. So for example, I'll just refer to two cases. The first of these cases is Lobby Odom and MEC for Education. This is a 1998 decision. And at the time, there were regulations dealing with the employment of educators in South African schools. And subject to certain exceptions, what these regulations provided was that only South African citizens could be appointed to teaching posts in state schools. And in that case, the Constitutional Court held that there was an unenumerated ground of discrimination, which is citizenship, and that these regulations violated that, were in breach of the equality provision on the basis of that ground of discrimination. Perhaps a more significant case, though, is the case of Khoza and Minister of Social Development. This is the 2004 decision of the South African Constitutional Court. And the legislation in issue in that case reserved certain welfare benefits only to citizens. And the constitutionality of this legislation was challenged by a group of permanent residents who were nationals of Mozambique. And in this case, the Constitutional Court likewise held that this amounted to unfair discrimination on the basis of citizenship. And they noted in their judgment that the exclusion of permanent residents from the scheme is likely to have a severe impact on the dignity of the persons concerned. I should in this regard mention that in South African constitutional law, dignity is often employed as the touchstone of whether the equality guarantee has been breached or not. So a breach of dignity is tantamount to unfair discrimination under Section 9 of the Constitution. This was a case that had significant fiscal implications by extending social welfare benefits to permanent residents. And it was also a contentious one given high levels of xenophobia in South Africa. Nonetheless, what the Constitutional Court noted is that in terms of the Constitution, the relevant right is quite clear, which is that everyone, not just citizens, has the right of access to social security. And as a result, the welfare benefit should be extended. They left open the question of whether temporary residents might also be entitled to welfare benefits as a result of this constitutional provision, given that that wasn't the issue before the court. Now, admittedly, there are rights in the Constitution that are specifically reserved to citizens, such as the right to hold a passport and the right to vote. But the overwhelming majority of rights in the South African Bill of Rights are provided to everyone. And the preamble, which I think a commentator in a previous seminar on this book described as Rogers Smith, I think, creating the imagined community of the nation, asserts that South Africa belongs to all who live in it, united in our diversity. So I suppose it's more of a supplementary note. I wanted to note the potential for the rights of equality and dignity to perhaps diminish the centrality of citizenship relative to other categories of residents. And I suspect this final reflection is more a book project rather than one that can be answered now, but I did find myself as a result of that also reflecting on how other categories of residents beyond citizens factor into our understanding of the people in a given jurisdiction. But as I say, I suspect that that's a lengthy project, so I'll leave my comments there.
Thank you, Murray. I'd like to invite Jo now to respond to Rayner and Murray if she'd like to. And I know, Jo, you'll remember that we do need to have some time available afterwards for audience questions.
Yes, thank you. Thank you very much. I think my I think my main yeah, I think the main point I think that comes across in both of those contributions, for which I thank you very much, those commentaries and questions. I think the main point that comes across is to push a little further, really, on the question of how it works and how institutions are involved. And I think that one could make a point, very much using Elizabeth Cohen's concept of the political value of time, about many of the examples that have been given by Murray and Rayner around issues of constitutional transformation. Yeah, and Australia, as much as South Africa is of course undergoing constantly processes of constitutional transformation. Some of them are more sudden than others, and some of them involve perhaps a wider range of actors than maybe the example of Australia and the federal constitution of Australia and the type of actors who were involved in that, compared to the new constitution of South Africa and it's much more inclusive approach. And that illustrates well, I think, in a way, that a lot of what I'm trying to get at in juxtaposing constitutions and citizenship is to really think about how processes of constitutional transformation, and to validate or challenge, as appropriate, the range of actors that are involved. Now, many constitutional courts have acquired a type of quasi-political capital within the system, that their adjudications of citizenship issues may be seen, and whether that's the scope of rights and the use of citizenship or nationality as a distinguishing factor, which is very much an issue in the South African case law, also in the Canadian case law on the Charter of Rights as well, is another example where that's, or whether it's dealing with really very unpromising constitutional material, as in the case of Australia, and trying to play around with ideas of the people, or ideas of alienage in order to try to sort of put together a convincing body of material. I think part of what it's often telling us is much about that story of how those institutions interact within the constitutional framework. So eventually, perhaps we learn much more about constitutions than we do about citizenship. Maybe it is that in the end, that citizenship remains this highly elusive, this highly contested idea, without which the modern bounded polity couldn't exist, but at the same time, which is constantly under challenge, because although we live in modern bounded polities, more so at the moment than normally, we nonetheless live in polities that are interacted, that are in constellations, as my friend and colleague Rayner at the European University Institute puts it. He talks about citizenship constellations, but it's really about the citizenship regimes. It's about the way in which the modern bounded polities interact with each other within a horizontal framing and within a vertical framing. So we can't escape from that, and within each of those polities, the conversation is ongoing. And as I say, it may not tell us that much about citizenship. We may end up never being, the process of citizenship is always in the process of being contested, of being formed and reformed. And maybe it is incrementally that we learn more about about processes of constitutional change, processes of constitutional transformation, and the role of different institutions within that, that we learn more about those from putting constitutions and citizenship into conversation with each other. So that's a sort of way, in a sense, then, of dodging the normative question that Rayner brought up, which is, you know, what are the candidates for constitutionalization in the citizenship realm? And you can't, you know, you can't escape from the fact that citizenship has this underpinning ideal of equality, but the reality of it is that it's treated as legally and ethically fungible by states and other political actors in that context, so that it's very hard to pin down a notion of equality that you could use in relation to citizenship, the, you know, membership within the modern semi-bounded polity. I say the bounded polity, but it's, you know, it's the tension between personhood and the bounded polity that keeps coming back. So yes, I think that's all I really wanted to say. As I say, I'm mainly about dodging the question of what ought to be there, in order to focus instead on how those conversations proceed. And I mentioned it on several occasions during the book, my perhaps surprising suspicion of the role of non-majoritarian institutions and the relationship between those two. And the point about the electors had passed me by in the state constitutions and so on. And so that's really helpful. Thank you for that. I think that's it really as to what I wanted to say. And yes, we should definitely leave time.
All right. Thank you, Jo. Now we have about 15 minutes remaining for some questions from our audience. Please type your questions, if you have questions, into the Q&A box at the bottom of your screen. You'll see a little clickable link. And if you like, specify to whom you're directing a question, or you can just leave it for us to figure out. We can draw straws. We will wait as patiently as we need to for you to formulate and type questions. Aha, Andrea Dolcetti asks, Jo, well, in fact, Jo, you can read that, but I'll read it out just in case other people cannot see this question. Andrea asks Jo, does a pluralistic approach to constitutional citizenship require us to rethink state-national sovereignty and its connections with the Constitution?
Thank you very much, Andrea. Yes, very much so. I think I was just wittering on there in response to Murray and Rayner about the tensions, and I think that one of the unspoken elephants in the room, if you will, is the idea about sovereignty, and that's why I do spend one of the points of the book. The point of the book, in a sense, is to get to what are chapters 6 and 7, which talk about the challenge of populism, which is about how to maintain that discursive space around citizenship, and then the challenge of shifting spatialities and the recognition that sort of modern constitutional polities, if they ever had any sort of sense of sovereignty in some sort of purist sense, certainly don't in terms of how they operate in the sort of the modern world. So yes, I spend quite a lot of time talking about how the extent to which there may be, for example, an international law of citizenship. Could there be an international law of citizenship that sets general norms that all states that claim to be part of the part of the sort of if you will, the mainstream of states should adhere to? And we haven't talked in that context about statelessness, and we could and should talk about statelessness and whether there are certain types of responsibilities that states have in the exercise of sovereignty around the degree and level of inclusion, and the recognition that citizens don't always fall into sort of neat parcels, if you will, or people don't fall into neat parcels, and there can be clashing norms between different systems, and the interaction between jurisdiction and territory doesn't always, and the fact that states choose different ways of regulating the scope of the membership of the polity doesn't always really fit well, and some people end up falling between the cracks, and in some cases states literally want people to fall between the cracks because they want to express that they have no responsibility for those people, and they may be reluctant even to accept that. So therefore, I think it's important to recognize that that while states have autonomy to determine who their citizens are, they still retain certain types of responsibilities in relation to ensuring that people, that people have the right to have rights, to quote the classic Arendtian principle of, that's why citizenship matters, because if you're not within that system, then which is premised upon the sovereignty of states, then you've got problems. So yes, we do definitely need to keep that issue in mind. We spent a lot of time discussing how, I've spent quite a lot of time discussing about transformation, constitutional transformation within states, but the operation of citizenship across states, raising in particular questions about sovereignty, is, I think, one where we could usefully pay more attention. Okay. You want me to go on and just look at Elisa's question there? Yes, who wants to know about the project? Well, one constantly tries to sort of keep going. I spent a bit of time trying to sort of stay on top of some of the sort of the new developments in that area, in this area, but then one could just accumulate examples. So the one which Rayner gave us of the American states changing their constitutions to be explicit about the eligibility of citizenship, of only citizens in order to vote in US elections is I think extremely interesting, and the sort of thing that one could definitely spend considerable time exploring in relation to the constitutional the process of constitutional transformation, the timing of constitutional transformation, the point I made before, borrowing from Elizabeth Cohen's idea about the political value of time, is I think important there. But what I'm actually working on is probably the same thing that far too many of us are working on, which is I'm writing a piece that's specifically related to the pandemic, and trying to explore a number of questions that arise around from the pandemic in relation to our my understanding of constitutional citizenship. So, are the consequences of the pandemic for citizenship simply linear? That is, are they simply the obvious and quotes natural consequences of citizenship, of changes. Are there any changes to citizenship? And the sorts of things there that arise are obviously the ones about borders and travel that has been discussed by Jaclyn, but there are also lots of other interesting questions to be raised about equality in that context. And I've been reading a little bit around what medical anthropologists call the syndemic, the idea of a synergistic approach to thinking about the pandemic, not just as a medical emergency, but also as a wider public health issue, and the consequences for the different groups of people who are differentially affected by the pandemic. So that was one question: was are the consequences simply linear? We're not seeing anything exceptional. The second question would be whether it's supercharging the impact of the pandemic. Supercharging the impact of populism. So, you know, is it raising and making sharper the distinctions that are being drawn, again, the issue of travel bans and so on and so forth. But of course, you know, that may not be a consequence of populism, and I think it's always very, very, very risky to ascribe things to being just, you know, this is the consequence of populism. And the third thing that I've been looking at is the third question that arises is the extent to which the pandemic really brings out certain types of paradoxes, if you will. So, you know, certain types of face coverings in the context of citizenship, bad. Other types of face coverings in the context of citizenship, good. And that's one paradox that I'm playing around with. And the other paradox is the way in which the pandemic is sort of bringing out, it's bringing out even a certain type of populism from below. So people who are protesting lockdowns on civil liberties grounds is what type of how do we reevaluate those processes in the light of principles of constitutional citizenship? Are they just active citizens expressing their concerns, or are they, and I'm putting this very colloquially, as it were, bad actors within the system? So that's what I'm working on. I'm working on an article about that.
There's been one more question come in, Joe. This might be our last one.
So if international law begins to effectively regulate citizenship, would that, in your view, not be detrimental to statehood per se, as expressed by commentators like Peter Spiro? Citizenship is said to be the last bastion of state sovereignty. What will be left of a state if that leaves its ambit of regulation? Yeah, I mean that is an interesting question, but probably as things stand at the moment, as it were, a hypothetical question. I think Spiro's point is more that is less about a sort of an international law of citizenship, and which is, I mean, there are plenty of norms around, not just around prohibition of statelessness, but there's material in the European Convention on Nationality, there's material in the Universal Declaration of Human Rights and various other international or regional international treaties. The human rights systems of Europe, Africa, and the Inter-American system all provide, or have been interpreted to provide, various norms. I think Spiro's point is more about how that operates in conjunction with the emergence of dual citizenship, which he sees as almost an international norm, in the sense of something that is close to being a sort of a right to be not just a single citizen, not to be consigned to single citizenship. And in that sense, the change couldn't be complete if one were not to also take into consideration the role of human agency in this. And that is, as many have pointed out, exactly why we have so many dual citizens, because of the consequences of human mobility and so on, which has dramatically changed the calculus in relation to what the implications of single citizenship would be in terms of massive reductions in people's autonomy and rights. And of course, Helen Irving has written incredibly powerfully about this in the context of the emergence of the norm of married women's citizenship following that of their husbands, and then the gradual dismantlement of that norm and the way in which that continues to hang over at the present time. So I regard the question as a little bit hypothetical, in the same way that I would regard, say, a question about membership of the European Union as being whether or not that's somehow dismantled national sovereignty, because it seems to me that, quite the contrary. I've always been quite convinced by David Mitrani's point about it isn't David Mitrani, I'm sorry. The name has gone now, it's not Mitrani. Alan Millward, the European rescue of the nation state. In other words, in an interconnected world, stronger international norms actually strengthen states rather than weaken them. And in that respect, for a state to be effectively networked within an emerging set of international norms around citizenship, around statelessness, around equality, for example, can actually strengthen the effective capacity of states to negotiate within a plural population, within a diverse population, the fact that membership has different meanings for different groups, and doesn't proceed simply on a sort of we don't expect it just to be all the same for everyone, and we don't just have one sort of homogeneous mass of citizens. We can recognize that also citizens are diversely positioned in relation. So my argument is that international law would actually strengthen states in that respect, rather than somehow taking away their notion of sovereignty.
All right, thank you very much, Jo, for taking that question on in the dying minutes. We are out of time, though, so I'd like to thank you, Professor Jo Shaw, for sharing your book, The People in Question, Bristol University Press, with us today. And I'd also like to thank our four commentators, Jaclyn Neo, Julia Sardelic, Rayner Thwaites and Murray Wesson, for their engaging commentary on Jo's book. And finally, I'd like to thank members of our audience for joining us today or tonight, depending on where you are. Wish you all a good rest of your day and stay safe and well. Thank you.